I guess the judge and Katie aren't on yet. You pretty much expect this to go the way Leva Ustigoff's hearing went when he did not appear?
Yes.
All right. Do you expect a second phase at a later time, or the judge?
Yeah, I guess it. I mean, potentially. I guess it's like that piece is kind of up to Judge Booley. I'm trying to remember if with Leva, if we had a second phase.
I don't remember either, but I think there was a break at least. It was either later that day or the next day or a week later. I don't. I wasn't sure if the judge needed to do a draft first, or gather his thoughts, or
right. Morning, Ashley.
Katie texted me and said that the internet's down in the court, so she might be a minute.
Okay.
Yeah, the IT guys are over there right now trying to fix it.
Yeah. Good morning, Ashley. Can you hear me okay?
Morning, John. Yep, I can hear you.
Good. I do not have Lewis with me, and I'll explain at the outset, but there's COVID in the household, and I think everybody's under a quarantine, and I'm at a hotel in Siren, and I don't think he should be here anyhow. So I'm in touch with him though, so I can communicate.
Yeah, sorry to hear that there's some COVID in his home.
Yeah, somebody was diagnosed yesterday. So.
Have you had a chance to visit with Lewis in person, John, or has it all been remote?
Well, I had a number of contacts a while ago, but lately it's been mostly by phone and some remote. Yesterday, I dropped off some materials at his house, and I spoke to him outside for a few minutes. But with the weather and everything, it wasn't an extended discussion. But I've had a lot of contact with him.
Yeah.
Again, while we're waiting, can you hear me?
Yeah, sorry, I was on mute.
If you think it's preferable, I could get Lewis on either the telephone or maybe by Zoom now, but because of the procedure, we can proceed without him, I think.
Yeah, I defer to you on that, John. I mean, if yeah, I mean, I definitely defer to you. I mean, I think if Lewis's intent is to is to do the default, it probably, it's probably easier to pull that off if he's not at the hearing. And then I don't think once you explain to the judge, and I think you did in the letter, but I mean, if the judge has additional questions this morning, I don't believe the judge is going to take it as Lewis being disrespectful or anything like that. I mean, given Lewis has, very valid concerns related to Fifth Amendment issues and self-incrimination. And I mean, I would assume the judge would totally understand that and be sympathetic to that issue. So.
Yeah, well, I'm kind of guessing, but I think he's going to understand the Fifth Amendment issue.
Mm-hmm.
We'll start without him, though. That's my plan. But I'll mention to the judge that we could bring him in to participate if the judge wanted a waiver or something on the record. I mean, my experience is mostly in the criminal world, and in a criminal case, you really have to have the person in court to do anything. But I think we're okay.
Yeah.
Good morning.
Morning.
We are here. Hopefully we stay.
IT problems this morning, Katie?
Yes, they had a hard time even connecting us for a little. We only have just the Wi-Fi in the courtroom.
Okay. And I resent the Zoom invite info to the judge.
And I just messaged him and let him know that we were here.
Okay.
What's the track number? Okay. Oh, there we go.
Good morning.
Morning.
Okay.
Good morning, Judge
Good morning.
and Katie.
Good morning.
Okay, is everybody here? That's going to be here?
Judge, I think we're ready to proceed. I do have some things to explain, but we can go on the record.
All right. Read the case, please.
The case today is in the interest of the St. Croix tribe versus Lewis Taylor. Case number 20-CB-209. Presiding today is the Honorable Judge Stephen Booley. Appearances for the record, Your Honor, are tribal attorneys Andrew Adams, Ashley Duffy, and Leah Jers, and the defendant's attorney, John Voorhees.
Okay, I call this hearing to order. This is scheduled for a trial. Mr. Voorhees, you said you had some explaining to do to the court. We can take care of that now.
Judge, thank you. The first thing I want to mention is that Lewis Taylor is not present on the Zoom video conference. I have given him the link, and he also has the phone information if he were to connect with the court that way. He is at home. And the first thing I should mention is that there's a recent diagnosis of COVID-19 within the household, and they're under quarantine. They've been dealing with that issue within the household for a couple of weeks. And I do have a release to discuss that if we need any further details. But the quarantine was initially expected to be up on Sunday, and then another household member had become ill over the weekend and tested positive yesterday. Actually, 2 of them tested positive yesterday. Mr. Taylor is not ill, but that's one reason, and it's the reason why he's not with me. I'm actually appearing from a hotel in Siren, and I did have the opportunity to consult with him on a regular basis by telephone almost every day recently. And yesterday I dropped off some materials at the house and was able to talk to him outside for a few minutes, but because of the weather, I don't think we could have extended that. But anyhow, that's one explanation that I have for the court. The other is consistent with the letter that I sent to the court on January 26, 2021, explaining the status of the case. There's been a number of contacts with tribal attorneys, primarily Andrew Adams, regarding how this case would proceed. And I feel comfortable telling the court that Mr. Taylor does feel a need to invoke his Fifth Amendment privilege to not incriminate himself through this and throughout this proceeding. And he's been advised of the circumstances I set out in the letter, and he agrees with the decision to not appear on the case. I would leave it up to the court's discretion as to whether or not you wanted him to appear and to obtain any personal waiver or invocation of those rights. But we do not contest the case at this point. And I have had discussions with Mr. Adams regarding his status. I would offer the January 26, 2021 letter into the record. I think it probably is anyhow, since it was sent to the court and relates to this procedure, but it explains things in a summary fashion. If we need any more details, I think I can talk about it.
Mr. Adams, do you have a comment?
Good morning, Judge. Attorney Voorhees is correct. After the pretrial conference where we had discussions on the record concerning the lengthy amount of exhibits that we're going to need to be introduced onto the record, after we had some conversations, a meet and confer concerning that stipulation document. And Attorney Voorhees can correct me if I'm wrong or if I make a misstatement. He expressed some concerns that his client had about testifying on the record and the need to invoke his rights to the Fifth Amendment's protections concerning self-incriminating statements. And so because of that, we talked about ways, really the only discernible way for Mr. Taylor to avoid having to provide testimony on the record concerning the checks that he received from the casino, concerning also the complaint that was filed against him by the tribe. The only way for him to avoid essentially making a self-incriminating statement would be either a blanket invocation of the Fifth Amendment or repeatedly stating that on the record. And so we discussed the possibility of Mr. Taylor not appearing this morning and essentially the court issuing a default judgment against him, you know, due to the fact that he did not plan on testifying concerning the receipt of those checks.
All right, here's where I'm at. I think I made it pretty clear that I needed the defendant to appear if he's going to contest the allegations. If he's not going to contest the allegations, he hasn't appeared at that particular point in time, or at this particular point in time, due to his non-appearance, the court would entertain a motion for default judgment from the tribe.
Yes, Your Honor. I mean, we can, the tribe can be prepared to file a motion for a default judgment pretty quickly.
All right, that's how I want to proceed. I can respect Mr. Voorhees' position on this. I can respect Mr. Taylor's position on this, but we are scheduled for a trial. I could take that verbally, Mr. Adams.
Okay, well,
I don't know that we need that in writing.
Okay.
Okay.
Yeah, so I mean, Your Honor, yeah, I mean, formally, you know, on the record, and if the court's willing to accept the verbal, you know, motion for a default judgment against Lewis Taylor, then the court hereby, the tribe hereby submits that on the record to the court that due to Mr. Taylor's non-appearance this morning, the tribe respectfully, you know, asks the court to issue a default judgment against him. And Your Honor, the tribe would also be willing to defer to the court in terms of how you would like to move forward concerning you know, damages and liability. If you would like to issue, if you would like the tribe to issue a proposed order, you know, concerning that, or if you would like the proposed order not to, you know, not to address those like damages, and the court takes that up, you know, later, the tribe definitely defers to the court concerning that procedure.
Mr. Voorhees, do you have a comment to the motion?
Judge, I have nothing further to say regarding the motion for default judgment. On behalf of Mr. Taylor, I'm not requesting a written motion to be filed, just as long as it's acknowledged in the record, which it probably would be by any judgment or findings.
Okay.
And I'm sorry.
Go ahead.
On just one comment about the stipulation was a pretty broadly based stipulation. So the record of exhibits is certainly available to the court, and I expect that to be confirmed shortly. But I have had conversations with Mr. Adams regarding the tribe's position about the defense making a statement regarding the damages and restitution in this case. And I would like to reserve the right to do that. I don't know if the court intended to convene another hearing or to you know, proceed on written documents at this point, but I would request that opportunity to at least be heard and to emphasize a few points that I think are relevant to those issues.
Okay, let's take one thing at a time here. First of all, there's a motion by the tribe, oral motion to the requesting the default judgment due to the non-appearance of Mr. Lewis Taylor. The court finds that Mr. Taylor is not present today, that he had notice of it from his attorney as well as probably from the court, the clerk of courts, and he has chosen not to be here. Due to his non-appearance, the court is going to grant the tribe's request for default judgment and find Lewis Taylor guilty of, I'm sorry, I don't have how many counts was he charged with?
Your Honor, there were, let's see. There were
10 counts. But
10, yep. Sorry about that. Yep, 10 counts, Your Honor.
10 counts is spelled out. I'm finding Lewis Taylor guilty of the 10 counts I spelled out in the complaint. Okay. Okay. Okay, Mr. Voorhees, you're saying that as far as the penalty portion of this order, you're going to want to address the court.
that's correct.
On the penalty. All right. Mr. Adams, how soon will you be prepared to present to the court? First of all, do you intend to present to the court anything different than you've already presented to the court?
No, Your Honor.
So are we prepared to have that argument today, or do you want to do that at a different time?
Concerning damages, Your Honor? I'm prepared to do it now, Your Honor. I mean, the tribe takes a standpoint. I mean, given the circumstances, I mean, the tribe is not going to contest the checks that Mr. Taylor received from the tribe's interstate department, but the tribe would take the standpoint that Mr. Taylor should be found responsible for restitution of all of the checks that he received from the St. Croix casinos that are outlined in the complaint, and that amount totals $211,418.64. And then, of course, Your Honor, the tribe would ask for, attorney's fees. Mr. Taylor should be responsible for attorney's fees that the tribe encumbered, up to this point, and whatever, court fees that the court has, related to, to the trial, at this point. And Your Honor, we can, the tribe can have the amount of the attorney's fees to the court by the end of today or first thing tomorrow morning.
Mr. Voorhees, are you prepared to make your argument to the court today?
I believe I can, Judge. Collect my notes and do that. Would the court be willing to allow Mr. Taylor to be present for that in light of the way the proceeding is going?
Does the tribe have an objection to Mr. Taylor's presence?
No, Your Honor, no objection to Mr. Taylor's presence. I mean, if his presence is, you know, I guess to, I mean, I guess the question that I would have is, would Mr. Taylor, you know, be given an opportunity to address the court related to, say, you know, his ability. I guess I'm just kind of curious as to what, I mean, Mr. Taylor, of course, I would have no objections to him participating so that he can hear straight from the court as to, you know, where things are going next. But if the court is going to entertain any type of testimony from Mr. Taylor, you know, concerning, say, his character or his ability to pay damages or whatnot, I believe that would be, you know, more appropriate for, you know, a full-blown, you know, damages hearing where, you know, Mr. Taylor has to, you know, fill out an affidavit of assets and, you know, make declarations on the record as to his, you know, solvency or his, you know, his ability to pay whatever restitution that the court, you know, deems not, like, appropriate and proper.
Mr. Voorhees, what would be the purpose of Mr. Taylor's appearance?
Number one, Judge, to simply hear the court and the parties explain their positions and findings at this point, just so he's fully informed about what happened here. Secondly, and I know in this court, I mean, the court actually used the term guilty in making your findings on the counts here. And I know in other hearings, you've also described this as a penalty phase of the case, somewhat like a criminal case. In a criminal case, defendant does have a right of allocution that is separate from, considered separate from testimony. I do understand that if he were to use that as an opportunity to start addressing specific evidence in the case, he would probably raise some concerns on the part of the tribal attorneys, because you can't, it's not our intent to use this as a opportunity to sneak in any new evidence. I think the court will be essentially making your decision from the exhibits that are coming into the court per the stipulation. There are admissions of liability that are included in that stipulation. There's already an acknowledgement that Mr. Taylor accepted checks and either cashed or deposited the 89 checks from the casino, as well as the interstate checks, which aren't really an issue for restitution. But then regarding the stipulation, there's also an indication that the exhibits can be accepted for the truth of the matter asserted. And they certainly explain the necessary facts for the court to make a decision in the case. Including the background investigation from the NIGC with the notice of violation and the proposed civil fine assessment and the settlement agreement being in the record. There's some facts in there that I was going to allude to, but I'm not going to get real specific, and I'm not intending to make a strong case of blame for anybody else. I think Mr. Taylor has to accept responsibility and liability in this case. I just think that there's some argument to make regarding some shared responsibility. And perhaps in the exercise of the court's discretion, some willingness to amend the requested amount of restitution. I realize that leaves it in the court's hands. But I guess I want to make it clear that Mr. Taylor has always been willing to work with me as an attorney in this case, and has discussed things, I think, pretty candidly. I think he's embarrassed, like other people are, about what's happened for himself, his family, and the tribe, and has a degree of remorse. I'm not encouraging him to go into any great detail about that, but he could make a statement along those lines. But I don't think you should talk about the individual checks, and I think that's position is consistent with invocation of the Fifth Amendment rights. If I could make one other point, I mean, I'm prepared to make, based on our discussions with Mr. Adams, I don't think we went into any detail on this, and I'm prepared to simply make a statement for Mr. Taylor as well, which I think will incorporate those elements, but I'd leave it up to you.
Yeah, Your Honor, I was going to suggest that perhaps if the court, like we would have no objections if the court felt that it was necessary to schedule a subsequent hearing related to damages and allow at that hearing Mr. Taylor, to make some type of statement, to the court for the court's consideration. The tribe would have no objections to that, and that scheduling a subsequent damages hearing would give both parties the ability to prepare, any type of, if the court wanted to hear some type of, testimony, or wanted to entertain any other evidence related to, I guess the severity of the restitution and whatever other type of damages that the court may levy against, Mr. Taylor.
So when would you envision this separate hearing taking place?
Yeah, I mean, Your Honor, the tribe's prepared to do it, yet this week, if I mean, especially given the fact that, we had most of the week blocked off for Mr. Taylor, or, I mean, if you wanted to, I guess if you wanted to hear from Mr. Taylor, now, it's just that my concern is that if Mr. Taylor's testimony is going to be specific to, like, say, his character or his ability to pay, or, I mean, that's one thing. He can testify to those things. But in terms of like the impact on the tribe, then I believe it would be appropriate for the court to hear, testimony from, a witness, from the tribe to discuss the impact of Mr. Taylor's actions on the tribe. And I would need, I would need some time to make arrangements for an appropriate witness to provide some testimony or an affidavit to the court related to, say the impact on the tribe related to Mr. Taylor's actions.
Friday morning at 9.
I'm sorry, Your Honor, what was that?
Friday morning at 9. What I'm going to want is I will want the tribe to put a detailed I'm going to want you to detail your order request, what you want me to put into an order. I'm finding Mr. Taylor guilty of the 10 counts as spelled out in the complaint. And I'm going to look for the tribe to provide a proposed order to the court. I'm going to want you to get Mr. Voorhees a copy of that order before Friday. Mr. Voorhees, if Mr. Taylor wants to make a statement, I'm going to allow him to make that statement. I'm going to want you to get to Mr. Adams, though, to discuss the content of that statement. So if Mr. Adams wants to provide a witness to make a counter statement or something counter to, or to explain to the comments Mr. Taylor would be making, they would have that opportunity to do that.
If I can respond, Judge.
I'm listening.
Mr. Taylor does not wish to open the door to more evidence that has to be countered in any fashion, and I'm not sure it has to. I think we're at a phase of the case where it's simply a little argument. I think his statement would only be that he's sorry and embarrassed about the situation now. As I indicated, it's not our intent to minimize the predicament or the situation the tribe is in as a result of this case and the entire investigation and other administrative actions. Simply to present a point of view to the court that reflects some considerations that I, as his attorney, think are important. It's and my last comment is simply that I don't intend to address evidentiary facts that are outside the record.
All right. I'm still at, let's do this on Friday. Again, you and Mr. Adams can clarify exactly what you're going to present on Friday. And if there's no need for anyone other than Mr. Taylor to allow him to make the statement that you've suggested that he wants to make, And if it's not beyond that, it'll be a short hearing. Other than the position that you want to take as far as what potential penalties being presented by the tribe. So 9 o'clock.
Judge Bully, the clerk.
I'm listening.
As far as working on the order, can we add the court fees to that order as well?
Oh, that'll come up when we get to the final part. And I thought I had a number in mind for that already.
Okay.
But you and I will talk about that later.
Okay.
Make sure that I'm on the same page with you on that.
Alrighty.
But as far as there is a number from the tribe already is on the table. Mr. Adams, would you be able to include your attorney's fees into that proposed order?
Yes, Your Honor.
Okay, if you would do that. Katie, what was the number you wanted for the court cost?
Did you want me to?
I thought it was $300.
Yes. Yes, that's what it was.
Because that's where I was at with this. Okay.
Judge, I assume you're going to exit the video conference and that Ms. Merrill would, after we complete this, is there a chance I could stay on with the tribal attorneys now just to discuss where we're going?
I don't have a problem with that. It's up to you, Mr. Adams, to work that out.
Yeah, that
Okay.
would be fine.
All right. Mr. Adams, you're the one who called us, right? So you don't need us to be here anyway, right?
Yeah, I mean, once you adjourn, Your Honor, you guys can leave the video conference.
Okay. Okay, this is a trial. This is the time set for a trial with St. Croix versus Bruce Taylor. Notices were sent out to the parties. Mr. Taylor is represented by Mr. Voorhees. Mr. Voorhees informs the client of this hearing. Mr. Taylor chose not to appear due to the non-appearance of the defendant. Mr. Adams submitted an oral motion to the court to enter a default judgment in favor of the tribe. The court accepted that motion without objection from Mr. Voorhees. We found the defendant guilty of the 10 counts found in the complaint. What we're going to do now is we're going to have a panel. We have I guess maybe a disposition hearing on Friday at 9 o'clock, at which time, as the parties agree about who needs to give testimony that day, but mostly what I'm looking for is a statement from Mr. Taylor. I'm not looking for new facts. I'm not looking for new evidence. I'm just looking for a statement about, I'm just looking for statements. Okay. All right, with that, the court's adjourned. We'll see you guys on Friday at 9. Mr. Adams, you'll send out the notices, or we'll use the one you sent us already?
The one that I sent already, Your Honor, would be fine, and I'll cancel the video conference invites that went out for Wednesday and Thursday of this week.
All right, let's do that. I will see you guys Friday morning. Court's adjourned.
Okay, thank you, Your Honor.
Thanks, Judge. Thank you.